Mayor, my lordship. My lordship, I beg to mention item number 7, my lordship.
7.
This matter may be listed after 2 weeks, my lordship.
Okay, you filed your affidavit?
Yes, we have.
Okay. Both sides are presented as paid for by Ms. T. Wangbul, and government advocate,
Kiwang.
just after 2 weeks.
And one more, my lordship. Item number 26.
22,
26.
26.
This matter may be listed on 3rd, my lordship. 3rd December.
Okay, same order. 3rd December.
Third. Problem.
May I, Your Lordship? Your Lordship, I beg to mention item number 24, Your Lordship. In this matter, Your Lordship, we have not filed our counter affidavit, so let's at least 3 weeks time may be given, Your Lordship.
Okay.
24, Your Lordship.
Okay, you inform the other side.
Yes, Your Lordship.
Okay.
I've informed Your Lordship.
Both sides are represented. On the prayer made by Ms. P. Pangul and the government advocate, 3 weeks further time is granted to file affidavit in opposition in the matter. List after 3 weeks.
Your Lordship.
Mayor, Lordship. Lordship, I beg to mention item number 8. I'm for the petitioner's side, and I've taken from the consent from the respondent side. Kindly, this matter may be fixed for the 26th of November.
26th.
Yes, Lordship.
Okay. Both sides are represented on the prayer made by Land Council for the petitioner, list on so and so.
Hello.
Mayor Lordship, Your Lordship, I beg to mention unlisted item, Your Lordship. Your Lordship, it is a bail application, Your Lordship. It was listed for motion on 7/11/2025. During the motion stage, Your Lordship, the name of the respondent number 3 was having slightly spelling mistake, Your Lordship. So, Your Lordship, this honorable court has directed the petitioner to correct the spelling of the respondent number 3. However, Your Lordship, in the order.
Give the mention of
But forgot to mention, Your Lordship.
how then we can't bring it. Otherwise, we'll have to wait. I'll have to go and bring it from the section.
Your Lordship, the matter may be taken in the last, Your Lordship.
No, but you'll have to give a mention memo. Otherwise, it will not come.
I will just file, Your Lordship.
Great.
Yes. Applies, Your Lordship.
Lordship, item number 12 may be allowed to withdraw with liberty, Lordship.
Why you want a liberty?
Lordship, we are unable to contact the client.
But that is not the reason to give you liberty. Because you'll have to come again. It's a 2022 matter. You are withdrawing after 3 years. We'll allow you to withdraw it. Item 12.
12,
13 also.
yes, 13 also, Lordship.
Just give that file 12, item 12. You pass separate orders. In item 13, you say on the prayer made by Mr. Yes, your name?
Yes, Iram, Lordship.
S.
Yes.
Iran, Y-A-R-A-N-G. The Land Council for the petitioner. The matter stands dismissed on withdrawal.
Lordship, liberty may be given.
This must have become infructuous by now. This construction of culvert.
Yeah.
I don't think for 3 years culvert would have any relevancy right now. Okay, same order in in item number. Twelve also.
Lordship, Liberty.
Hmm?
Liberty maybe.
Liberty, you can't get it. You see, it's a case of culvert. You want the PWD to construct a culvert at a particular place, and then you say that you also acquire the land. Correct? For that, you can't get a liberty.
May your lordship, I'm mentioning one criminal petition for listening on Monday, your lordship, for order, your lordship.
Monday, kindly make a mention on Monday. Correct?
Lordship.
Monday, I
lordship,
think there's likelihood that senior judge may come.
Okay, lordship.
May I Lordship, I beg to mention item number 3.
Three.
We have taken consent from order 40. I am appearing behalf of T. Tapax.
Okay.
3.
Okay, both sides are present on the prayer made by learned counsel for the petitioner. List after
2 weeks.
2 weeks.
May it please your lordship, I beg to mention item number 14 and 25. The matter may be adjourned and be listed after 3 weeks.
14.
14 and 25.
Okay, 14 and 25. You have taken consent of the other side.
Yes, your lordship.
Both sides are represented on the prayer made by learned counsel for the petitioner. List on. Next Wednesday is 26, 11, 2025.
25, item number 25.
Item number 1.
May I, Lordship?
Yes.
Lordship, there is some defect in this application, Lordship. So we want to withdraw it with the liberty to file a fresh, Lordship.
Okay. Ms.
M. Bori, Lordship.
M. Bori, then counsel submits that there is some inadvertent mistake in the bail application, and therefore she craves leave to withdraw this bail application and to file again. Prayer is allowed, matter stands dismissed on withdrawal with liberty as prayed for.
Obliged, Lordship.
Item number 2.
May it please your lordship.
Yes.
My lord, this petition is directed against the impugned retention order, which I have annexed as Annexure 13 at page 48, my lord. But before that, my lord, may I just take your lordship to the annexures, my lord.
No, this something else has come. Different file has come. This is only one table. This is it's okay. Yes.
My lord, in the state of Arunachal Pradesh, there is guidelines for transparent posting, my lord. May I just take your lordship to that guidelines, Annexure 3 at page 26, my lord.
26.
26, my lord. My lord, the type version is at page 30, my lord. Let us see.
Yes.
My lord, here, point number 1A, no officer of group A and B should be posted in his home district so that he does not develop vested interest. But And then, my lord, according to these guidelines, my lord, the tenure of posting is fixed at 2 years. Now, my lord, although these guidelines are not statutory in nature, but nevertheless, it is the basic structure, my lord. So, my lord, this the respondent number 4, he has been posted at Yingkiong since 2023, my lord. As on today, he has completed his tenure, and therefore, my lord, at page 34 is the posting order of. Now, my lord, then
Who is?
11 July 2023 he was posted there.
Just a moment.
Then I was
His name
posted
is, Kari-
page 34.
His name is Kari Kapang.
Correct? Yes, my lord. Serial number 5.
Yes.
No, my lord.
He is posted to Yingkiong.
Yingkiong.
Yes.
Then, my lord, here in this serial number 4, I was posted at Itanagar. Then again, in 24, my lord, the type version is at page 36, my lord. 34 by this order. Lordship may kindly come to page 36 I just taken an extract of my posting 24, 5th August 2024. I was posted at SEPA.
Yes.
Then again, my lord, within a period of 1 year and 2 months, I was posted, transport out, page 36, 37, my lord. My lord, page 37. Serial number 2 is me. Serial number 3 is R4. This is 29 October 2025, my lord.
Yes.
My lord, in pursuance to this order, as a government employee, I have abided by this order. At page 38 onwards, Annexure 7 Koli, my lord, I have handed over the charge of SEPA to my reliever, my lord. Page 38. Then I was released from the circle office. Page 39, Jamiri SC circle. The SEPA comes under Jamiri circle, my lord. Then, my lord, at Annexure 8, page 40, my lord, the type copy is 41. My lord, I have joined at Pangan SC circle, my lord. Yingkiong division falls under Pangan circle, my lord. So I have joined at my posting place. This is on 6/11, my lord. I have joined on 6/11. Then, as an acquaintance, I have also sent a message through WhatsApp at page 42 that I am reaching Yingkiong and to kindly prepare the handing and taking over documents, my lord. Now, my lord, when I went to Yingkiong on the next day, 7th, after reporting on 6th, 7th, my lord, I found that the respondent number 4 was not at the station, my lord. So having joined at the circle level, I have taken over the charge at page 43, my lord. And by this page 44, Annex 10 Coli, I have informed the circle superintending engineer, page 44, Malat. And also the
43, you took charge on 711.
711. Then, Malat, page 44, I have informed.
Can you take ex parte charge or somebody?
Yes, yes, I'm coming to that, Malat. There is an office memorandum, Malat. I'm coming to that, Malat. Malat, then page 44, I have informed the circle superintending engineer. Also, copy was given to DC, State Bank, DTO, and also the secretary of my department on 10/11, Malat. Now, Malat, this assumption of the charge has been carried out by this office memorandum. Malat, you lordship may come to page 45, Malat. Now, Malat, these clauses are also important, Malat. May I just read these clauses, Malat? Page 45, Malat. A government servant holds office at the pleasure of the government. Government issues orders regarding transparent posting of officers from
It's
time.
okay, we saw that paragraph 4 says he can take over charge.
Yes, yes, Malan.
Huh.
Malan. Now, Malan, having assumed the charge, taking over the charge, I have started discharging my duty as executive engineer. I have started visiting the work site, Malan. Page 47, Annex 12, Malan, is a photograph just to show that I have started working, Malan. Now, Malat, suddenly at page 48, Malat, this is the impugned retention order, Malat, and transferring me out within 4 days of my joining, Malat.
Yes.
Malat, page 48, Malat, here serial number 1 is the R4. He has been retained at Yingkyong WRD division as EE. Serial number 2, that is the petitioner. He has been transferred to Dapurijo. Malat, in this entire order, there is no word called it is in public interest. Now, whereas in my order, it was clearly stated that this is in public interest. Now, Malat, how this impugned order had started, Malat? Malat, page 49 and 50. Malat, this is the note initiated by 2 MLAs. Malat, the language of the notes, it is not only recommending types, Malat. There is forceful demand. Malat, totally political in nature. Malat, may I just read, Malat, because this is very important, Malat. With due respect, I would like to bring to your kind notice that Engineer such and such, Executive Engineer such and such, has been transferred from his present place of posting. In these connections, I would like to strongly recommend for his retention in Yingkyong. Engineer such and such has been performing his duties with utmost sincerity and efficiency. And under his supervision, several important WRD projects in the district are progressing smoothly. His transfer at this crucial stage may disrupt the ongoing development activities and delay in completion of the key works. Considering his valuable service, dedication, and the importance of maintaining continuity in the execution of departmental projects, it is therefore earnestly requested that Sri such and such may kindly be retained at his present place of posting in the larger interest of public service, Malat. Now, Malat, this certification given by the Honorable MLA, it is not the recommendation of the administrative heads, Malat. There is no departmental wording that he is the efficient, his transferring out will suffer, Malat. Now, Malat, here interestingly, Malat, the MLA, he is the MLA of 34 Tuting Yingkiong Assembly constituency. And respondent 4, my lord, in my writ petitions, I have stated that he is from Karko village, but I'm sorry, my lord, he is not from Karko village. He is from the other adjacent village, Ramsing village. My lord, I'm sorry. They comes within the same assembly constituency. So this is only to appease his family members and to the R4. Only this has been written. My lord, it is not for the MLA to certify that the developmental projects will suffer. Now, my lord, annexure 15, my lord. Page 15, next page, my lord.
Yes.
My lord, here, this is the MLA note of the adjoining constituency, my lord. That is Mariang Geku, 40 Mariang Geku Assembly constituency, my lord. Now, here language is, my lord. I write to bring to your kind attention the matter regarding the transfer and posting of such and such and such, who has been transferred and posted to the Purja Circle as such and such and such, dated 29 October 25, as he is known to me personally since long, and he is a sincere and dedicated officer. His dedicated service is directly needed at Upper Siang district, and his posting from Yingkiong would hamper the developmental works in view of the above such and such, my lord. Now, my lord, here it clearly depicts that he is a close friend of the R4. My lord, personal knowledge and acquaintance, my lord, this is how the MLA is certifying. Not on public interest, my lord. Now, my lord, interestingly, the note, after getting these two notes, the notings, how the file moved for retention, my lord, page 51 onwards, my lord. Page annexure 16, my lord. Down below, my lord. Subject proposal for retention of research and sciences. My lord, here, on receipt, your lordship, page 51, my lord, down. On receipt of a UO note from local MLAs, 34 to such and such, advisor to ACM and MLA 40 Geku Mariang, the Honorable Minister has desired that the proposal for retention of research and sciences be processed for further consideration of the government. The endorsement of Honorable Ministers in body of the note is may kindly be seen. As per Government Order Number such and such 2910/2025, referred such and such was transferred to the Purijo, and Sri Gonong Patin, the petitioner, was posted in his place at Yingkiong WRD Division as EE. In pursuance of the said order, Sri Gonong Patin has handed over the charge of EE SEPA WRD Division on 4/11/2025 by certificate of transfer of charges uploaded at such and such and such, which may kindly be seen. Subsequently, SC Jamiri WRD Circle has released him from SEPA on 6/11/25, enabling him to join his new place of posting by order number such and such, which may be perused at such and such. As per the disposition list of EE, the transfer and posting order of Sri Gonong Patin from SEPA division has been issued before completion of his normal tenure of 2 years. Meanwhile, both the MLAs that retention of Sri Karik such and such is desirable for maintaining continuity in the execution of ongoing departmental projects. It is, however, submitted that transfer and posting of officers is the prerogative of the government to be exercised in the agency of public service, my lord. Now, my lord, these notings, file notings clearly indicates that they have exerted pressure on the Honorable Minister, concerned minister, and accordingly, the concerned minister has directed that this should be processed. So, my lord, my respectful submission here is that there is no public interest involved here. My lord, I have tried to meet the secretary to ventilate my problems by submitting representations, but secretary also was very, very frank said this has come from the top, so there's no point. So whatever you want to do, you do it whatever manner you want to do. So that's why, my lord, I have directly come to this honorable court. Now, my lord, I have attempted to project that this is no regions, no public interest element is involved, and the regions assigned by the MLS are personal, not in public interest, and therefore it is no reason for issuance of the retention
Hang on,
order.
any
But
cases?
in these connections, I have some.
We should take this book.
My lord, this is our own High Court Kohima bench decision, 1997 1 GLT 140, my lord.
Yes, what is it?
1997 1 GLT 140. My lord, I'll just come straight to paragraph 8, my lord. Come to paragraph 8 and 10.
Yes.
May I read, my lord? This court in a catena of decisions has held that for cancellation, modification, or keeping in events of the transfer order passed in public interest must be supported by sufficient reasons necessitating for passing such order. The view taken by this court has rationale behind it. Once the transfer order is made in public interest, court normally do not interfere unless the order is passed with malefied or against the statutory rules. The only way open for the aggrieved government servant is to file a representation before the competent authority to redress his grievance. But this court insists that for cancellation of oblique modification or keeping it events of such order must be supported with sufficient reasons because transfer of officers are always made in public interest and after elaborate exercise as to who should be transferred where in the exigency of the administration. While processing the transfer order, various factors are taken into considerations. One such factors being the duration of the stationing of one officer in a particular station for a long time. If an officer is posted in a particular station for a long time, no doubt that he also acquired a considerable knowledge about the administration of the area, but at the same time, he also often establishes vested interest in the area because of his long association, and to avoid such eventualities, timely posting is always called for. Therefore, if the transfer order made in public interest is allowed to be taken away by another cryptic order, modifying, cancelling, or keeping in events of the transfer order without assigning any reasons, it ceases to be in public interest. Therefore, it must be held that the order has been passed at the whims and caprice of the authorities exercising the power. Public interest would not be allowed to be sacrificed at the altar of the whims and caprices of authority exceeding the power. It seems not grasps in that public authority possesses power to use for public interest. Now, my lord, the operative portion is at page paragraph 10. As already said, the impugned order dated 14 to 96 and the impugned order dated 5/12/94 as quoted above lacks reason. Lacks sufficient reason, and therefore it cannot pass the scrutiny of the law. The impugned order will question set aside, my lord. Then, my lord, Now, I have another judgment. It's also by our own, by this court only, Manoj. May I just take your lordship to paragraph 4 onwards, Malad. 2001 3 GLT 67. 67. Hmm. Yes, Malad, in paragraph 4, Malad, next page, Malad. In such and such, this court held in paragraph 6 as follows. Quote, from the above not quoted orders, it would clearly show that from the period from 18/9/95 to 13/10/95, as many as 3 transfer orders have been passed. This would clearly show that the order has not been passed after application of mine, but with an unholy haste, and therefore it cannot be said that the appropriate authority has exercised the power vested in them in public interest. From the instances recited above, it would clearly reflect that the mind of the authority has been influenced by extraneous consideration. Powers are being misused in the guise of public interest. Surprising enough, all the aforesaid orders have been passed by the same officer, and yet no region has been assigned necessitating of passing of the impugned order. Once the transfer order is made in public interest, subsequent orders cancelling or superseding must be supported with sufficient reasons. Again, in the Rogliai Angami case, Malad, which I have just now quoted, Malad, this court at paragraph 8 of the judgment held, Malad, the paragraph 8 has been quoted. Now paragraph 6, Malad, of this, after
Yes.
quoting paragraph 8 of that earlier judgment, the principle laid down in both the cases is that once transfer order is made in public interest, subsequent orders cancelling or superseding must be supported with sufficient reasons. If any such order is passed in cryptic manner without assigning any reasons that would seem to be not in public interest. Now, Malad, I have taken your lordship to the note sheets of this thing. There is no reasons. The only reasons is the MLA note. I find for
Please reply from, if you have any decision, please cite that.
Malad, I have another one.
Same ratio.
Same ratio, Malad. Here in this case, this is also mentioned matter by this is another bench. Malad, here also on the basis of the MLA note, Malad, factual aspects are slightly different because here they have attempted to misguide also by, in order to support the MLA note, they have tried to show that this was based on the public complaint. But then in that public complaint also, it was proved that that public complaint was afterthought, because one of the signatories, he has put the date, the original date when they signed, that is 16/4/2023, and whereas they are showing that this was in 15/2/2023. So there also, no any other reasons were there. I just
Paragraph.
paragraph 12, my lord.
Okay.
May I read, my lord?
No, not required.
Oh.
We have to, what you call, ration time today.
My lord, here, the election is there next month, because it is preferable that though it is not in the panchayat this thing, but in the manual for the presiding officer, it is slightly mentioned that as much as possible, the persons who are in the polling booth, in charge of polling booths, should not be from the same area or same district. So, my lord, assembly also is coming out. Panchayat election is coming up now. So, my lord, my respectful submission is that at this stage,
Can we
At
can we
least-
wish you good luck there? No.
uh, having shown your lordship that the notings does not reveal any public interest material, only based on MLA note, this is totally on extraneous considerations. And this is, my lord, maybe at best,
Yes.
notice maybe should then interim order, my lord.
My lord, before I start with this case, I tender my apology for yesterday, my lord. I have to rush back to home, my lord. Yesterday, my lord, I missed that opportunity, my lord. The lecture on CPC that was delivered, your
No,
lordship,
that-
my lord. I
no,
have to
no,
rush back
that's-
home, my lord, because
that
of my
was-
second son birthday, my
No,
lord.
that is not intended, that was never intended for you. This is only for young, it was aimed at young people.
My lord, still I am young and still I am learning, my lord. CPC, my lord, my lord, CPC especially.
Then wish you a very happy Children's Day.
CPC, still I am confused with the, my lord, rules and orders, my lord. Anyway, my lord.
No, you are right. You are right in a sense, because for a lawyer and a judge, every day is a learning process.
Yes, my lord.
But still, you see, Mr. Nabam, we have to respect you not only for your the achievement you have in the profession, also respect to your age,
Right.
and therefore we can't assume. But we can't. I never thought that I would be addressing you. It was only intended for young boys and young lawyers, young advocates. Sorry, not boys, young advocates. Nothing more. See, something I can share.
My lord,
There's a little thing which I can share. I have no other things to share, but this is the only thing which I can share. These procedural parts, CPC, CRPC, and Evidence Act.
So, my lord, we are deeply obliged, my lord. My lord, coming to this case, my lord, what we have seen, my lord, 2024, the present petitioner, my lord, is shown to be, my lord, a very good officer, my lord, and dedicated, sincere, my lord. 2004, when he was transferred to somewhere else, my lord, within a year, my lord, he has no any complaint, my lord. He has proved himself to be a very good officer, obedient. Now, my lord, we expect, my lord, the same spirit to be followed. The petitioner were transferring in 2025, my lord. Now, so far, my lord, these guidelines and the notifications are concerned, my lord. Your lordship aware, my lord. I don't have any dispute. Now, guideline basically, my lord, is to regulate ourselves, my lord. My lord, it has been already decided that Poonam Burma case, your lordship, remember that Delhi Development Authority, my lord, wherein says, my lord, the guidelines does not have that statutory authority, where under my risk proceeding that can be enforced, my lord. So, my lord, I don't dispute, my lord. Basically, guidelines is to regulate, my lord, for transferring the officer, but it does not put any sort of embargo to the authority that they can't, my lord, transfer out the officer agent when required for the public interest, my lord. So that is number one. So far, guidelines is concerned, my lord. So far, my lord,
What is that citation of Poonam?
my lord, Poonam Burma versus Delhi Development Authority. It is
Poonam is how do you spell?
POONAM, my lord. POONAM Burma versus Delhi Development Authority. It was reported in AIR 2008 SCC. Page should be, my lord,
AIR?
2008 SCC 870. This should be the one, my lord.
Volume? Okay.
AIR, there is no volume, but page number is 870.
870.
I think this is the first, my lord, wherein, my lord, pertaining to, my lord, the guidelines that was decided. Now, my lord, coming to, my lord, this before notification where the officer can take ex parte, my lord, charges. Now, your lordship may kindly note, the petitioner was, my lord, released on 6th from Sepa and Hinkyong. I believe the kilometer would be not less than 300 kilometers, 300 to 400 kilometers. My lord must be, my lord, very separate speed, my lord. He reached there and submit the joining report. Same day, if your lordship sees, my lord. I don't have exact kilometer, my lord. He was released on 6, my lord. He resumes or assumed the duty on 6, my lord.
On 7th.
Huh?
He takes on 7th.
No, 6, my lord. Huh? 6, my lord. He joined 6. Expertise charge was taken on 7, my lord.
Huh.
Expertise. I'm
Expertise.
talking about the joining, my lord. So from Hinkyong, from Sepa to Hinkyong is not less than 300 to 400 kilometers. Anyway, my lord, I'll not on that, my lord. Now coming to my lord,
You see, these things can't be subject matter of discussion.
My lord,
Reason is why I'll tell you.
my lord, you lost me. Kindly understand, my lord.
No, I'll tell you why.
My lord, why I'm saying I am in my lord.
Let me tell you
I'm in
why.
pendulum on both sides, my lord.
No, let me tell you why. Sunday at till 2 o'clock,
My lord.
I was attending a conference in Delhi. 3 o'clock, I had my lunch and took the car, went to the airport, got a flight, came down to Guwahati. I reached Guwahati at about 8:30. I traveled to railway station at 10:30. I boarded the train and I was here in the morning.
My lord, I think we should thank the technology that we have, my lord, air service, my lord.
No, not that. But you see, I'm telling you, if you have the idea of serving in mind,
My lord.
that I am assigned a duty, I must be here at 10:30. That means I'll have to be here at 10:30. And it's a conference in the Supreme Court, so it's.
My lord, that's
I have
why I
chosen
said,
and
my lord,
therefore-
I'll not give much stress,
Just
my lord, on
slight,
that point,
slight
my lord.
corrections, my lord. His handing him taking over was taken on 4th November.
Sorry, you have given the
This
6
see the
release. I'm talking about the release order. You have been released on 6. You join on 6, my lord. Anyway, my lord. Now, my lord, coming to my lord, this most important that expertise charge, which my lord, the petition took on 7, my lord. Now, expertise charge can be taken under what circumstance? If your lordship kindly come to my lord, paragraph 4, my lord. There are certain conditions, my lord. It's not that, my lord, abruptly you'll go and take over the charge, my lord. May I just read, my lord? Page 45. Has your lordship got it? In case where the reliever officer does not hand over the charges, my lord. First, you make a submission that you report that I have joined, kindly hand over the charges. It's not that the person is on leave or something like that and you go and you assume the expertise charges. It's not that. There are certain conditions, my lord. Some sort of SOPs are there, my lord. I think this was not compliant by the petitioner. They both are colleagues, my lord. They should have some understanding anyway, my lord. Now, my lord, next is coming to my lord, MLA noting, my lord. My lord, there are catenary of judgment, right from my lord, the great my lord Mahmood Masood Ahmed case, my lord. Now, these are the, my lord, public representatives, my lord. They know better than any other, my lord, who are the officer, my lord, good for their area, for their localities, for the scheme and other development activities, my lord. And these two MLA, my lord, they represent, my lord, this constituency, my lord. MLA constituency is very big, my lord. They know the officers, my lord, who is doing good job or not doing a good job, my lord. And if your lordship minutely notes, my lord, they have said, my lord, some ongoing projects are going on, my lord. And this gentleman, perhaps he must have initiated the project and project must be at the verge of completion, my lord. So if that be correct, my lord, that cannot be better than any public interest. My understanding says so, my lord. If your lordship says, my lord, once again, my lord, the MLA noting or my lord, office noting, my lord, subject to correction to other side, my lord. My lord, page 52, my lord, the office note,
Just a moment.
my lord.
Yes.
My lord, I was referring to page 52. This is the official note, my lord. The file process, my lord. Your Lordship may skip the first paragraph, second, third paragraph, my lord. Meanwhile, it starts with the meanwhile. Both the MLAs of the area have submitted a U note stating that retention of series so-and-so, the private respondent at Hinkyong WRG division is desirable for maintaining continuity in execution of ongoing departmental project, my lord. This is the reason, my lord, they wanted that these officers should continue till the completion, at least till completion of the project. Now, this indicates is a public interest, my lord, not personal interest. What my other side, my lord, try to project that friendly relation or something like that, my lord. So there is a need of public interest, my lord. So perhaps that could be the reason, my lord, why he has been retained at Hinkyong, my lord. And other reasons, my lord, I don't see. And so far, my lord, MLA notes the ipso facto effect of the MLA note will not be as the transfer posting. If your lordship knows, my lord, the Masur Mehmet Ahmed case, my lord. 2007 SCC, my lord, 8 SCC, my lord. Page 150.
2000?
2007, 8 SCC, 150, my lord. So herein says, my lord, the representative MLOs MPs, they are any sort of, my lord, recommendation, note, that will ipso facto, my lord, not be as the transfer posting, my lord, which was, if it is taken on, my lord, public interest, my lord. And so far, my lord, the ratio which my friend has said, my lord, this 1997 GLT, my lord, I'm not disputing the ratio led in this judgment, my lord. What he says, my lord, there must be a reason, my lord.
Yes.
Yes, my lord. The law cited by my other side, my lord. I agree with the proposition led by my lord, the Guwahati High Court or any law in this regard, my lord. For any retention, modification of any transfer order, there must be a bona fide reason, my lord. I agree to that proposition, my lord. That's why I've said, my lord, the MLA notes, the file note that indicates because of ongoing project, my lord, this officer retention is necessary, my lord. That could be, my lord, reason why, my lord, the private respondent has retained, my lord. The only problem is that, my lord, my problem is, since my other side has already assumed and my lord started functioning, if that be correct, my lord, but which also reflect in the note, my lord. Note reflects, my lord, he has assumed all that, my lord. That is the only, my lord, the problem I'm facing, my lord. Otherwise, my lord, there is nothing wrong in this, my lord, impugned order. That's my submission.
Yes, Mr. Doctor.
My please, Lordship. My lord, I'll directly come to the recent judgment of the Honorable Supreme Court, my lord. In this case, in our Guwahati High Court case, my lord, in that what happened, transfer order was modified by the government, my lord. Then the learned single judge, my lord, dismissed the writ petition, my lord. And the petition went to the division bench of our High Court, my lord, and the division bench reversed the order saying that the recommendation or your note of MLA is acting on that letter would be kind of malafide action. And this matter went to Honorable Supreme Court, my lord. Supreme Court quoted all Mahmoud, my learned friend just quoted Mahmoud Masood, and all those judgments were quoted, and come to the conclusion that your note itself wouldn't be the justification for cancelling the government's order, my lord. My lord, may para 10, my lord, starts from para 10, my lord. The other was those judgment, all those judgments has been quoted, referred to here, Mahmoud Masood and all that, my lord. Abbas case and all that. Para 10, my lord. In view of the foregoing enunciation of law by judicial decision of this court, it's clear that in absence of pleadings regarding malafide, non-joining of a person against whom allegation are made, violation of any statutory provision, the allegation of the transfer being determined to employee who is holding a transferable post judicial interference is not warranted. In sequel of the said settled norms, the scope of judicial reviews is not permissible by courts in excess of jurisdiction under Article 226 of the Constitution of India. On examination of facts of the present case, it is apparent that the respondent here was transferred from the Government Higher Secondary School, GSS Kanubari, Longding District to Laparada as Deputy Director of School Education, White Order dated 15/11/2022, and was directed to join the last part of April 2023. The UO note dated 28/2/2023 has been written by the MLA specifying the administrative exigencies and public interest in posting the appellant on the post of DDS Laparada. The said UO note has been examined and a competent authority has exercised its discretion in favor of the appellant, and the respondent number 5 herein has been retained on the same post in the same district in the same status which he was holding prior to order transfer dated 15/11/2022, unaffecting his salary. Besides, it's also averred by the state that the modified order dated 24/2023 was passed prior to effective period during which respondent number was directed to join, that is last part of April 2023. As per the counter affidavit filed by the state government, even before us, it is specifically averred that the order of transfer dated 24/2023, modifying the previous order dated 15/11/2022, has been issued in public interest after due application of mine and without any malafide intention. As far as the stance of respondent 5 herein is concerned, the plea of malafide against transferring authority has not been agitated even before this court or the High Court. Further, the impugned transfer order is also not alleged to be violated by any prescribed statutory provision. In view of the stand taken by government and in absence of plea of malafide and no averment regarding violation of statutory provisions taken by the private respondent before High Court, interference as made by the division bench, setting aside a well-reasoned judgment of the single judge, is not justified merely on the unsubstantiated pretext that the proposed modifications are arbitrary or without application of mine, for the sole reason that it was mooted by the MLA. In our view, the division bench has committed an error in setting aside the judgment of learned single judge. According, the civil appeal is hereby allowed, and judgment and order dated 29/2 passed by the division bench of High Court is hereby set aside, restoring the order dated 11/7/2020 of the learned single judge. This is the judgment, Mala. So in this judgment, all those leading cases has been referred to. And our own High Court, my Itanagar bench, yes, good one of. It's 19. Supreme Court तक पहुंचा.
That too by Mr. Patel.
Yeah, this one, yes. Same man of the judgment, he has just referred to, those judgments were referred in this case also, man.
Okay. Mr. Patel, you are not ready to showcase your own achievements. Yes.
Para 19, my lord. I'll just rest. This is also same, or transfer order was modified, and in that regard, this order was passed. Para 19. As has been mandated by category of cases, including the cited case of Masood Ahmad versus State of UP and others, wherein the apex court held that transfer is an exigency of service and is an administrative decision, and interference by the court with transfer order should only be in a very rare cases. As repeatedly held in several decisions of Supreme Court, transfer is an exigency of service. It should not be interfered with ordinary by the court of law in excess of discretionary jurisdiction under Article 226 unless the court finds that either the order is malified or that the service rules prohibit such transfer or that the authorities who issued the orders were not competent to pass the orders. It has been discussed in above case laws that even if the allegation of appellant is correct that he was transferred on the recommendation of an MLA by itself would not vitiate the transfer order. There can be no hard and fast rule that every transfer at the instance of MP or MLA should be vitiated. It all depends on the facts of circumstances of individual cases. In the present case, it is found that the private respondent number 3 having genuine grievance against the transfer order, which was made before the completion of his tenure in place of posting. So he has moved the higher authority, which was ultimately acted upon and resulting in a modification of the said transfer order, which has been impugned in this case. However, after going through all the materials on record, there is no scope to hold that there was an affirmative or malified in the impugned transfer order so as to interfere with by this court. However, the petitioner may approach the respondent authorities to ventilate his grievance, if any, by way of submitting proper representation that the authority concerned or received the same shall consider and pass necessary order in accordance with law. Here also, my lord, the petitioner has neither approached the authority, my lord. He should have filed a representation before the authority, and if they don't consider done, only he ought to have come before this honorable court. He has simply, my lord, after receiving a transfer, this modified order, he has rushed before this honorable court. It is understood, my lord, transfer, anybody can file a representation before the authority, my lord, and if it is found, my lord, the representation is genuine, my lord, the respondent authority will definitely, my lord, alter or modify the transfer orders. And there's nothing malified in this present impugned order. Therefore, I pray this honorable court may not stay the order, because the respondent is continuing with his duties at the present place of posting. That's all.
My lord, I just want to make some clarification, my lord. My lord, both we have quoted all this historic judgment, Mahmoud Mashood and SL Abbas and other things, my lord. Now, my lord, those principles are not disputed. And also, it is not disputed that in those cases, it was made clear that simple recommending types of notes may not be a ground. But here, my lord, in ML Mahmoud Mashood case also, it was clearly provided that unless the court finds that either the order is malified or that the service rules prohibit such transfers, or that the authorities who issued the orders were not competent to pass the orders, my lord. My lord, in my GLR case, Gumnong Singpo case, my lord, your lordship has quoted this paragraph, my lord. My lord, that is the principle, my lord. I'm not saying that the MLA, just because MLA has issued a note, that's why it is malified there, or it is under external considerations. But now, my lord, as far as the distance and then try to show this thing, my lord, Jamiri is located near the Nachipu. No, not Domji. From Nachipu. It doesn't even reach Tenga. And from there, Balukpong will be about 1 hour's drive. Balukpong to Itanagar is maximum 2.5 hours drive. And from here, Pangin will be about 5 hours drive. So, my lord, it does not say that you cannot travel from Jamiri to Pangin and then submitting my joining report. And, my lord, my submission is, my lord, at page 434, this is my transport order from Pasigat to Itanagar. Then this is 11 July 2023. Then again on 5th August 2024.
You may not repeat again.
This is without abiding the transfer posting policy. I have also submitted that these guidelines are not statutory in nature, but then this cannot be discarded with impunity. It regulates, as Mr. Navam has submitted, it regulates the policy matters. So it cannot be just discarded away, and at times they will apply this. No, my lord, therefore, my lord, my respective submission is that why MLA notes are malafide, because this is their personal and political opinions and not administrative justifications. Neither of the notes discloses any specific public interest, administrative necessity, or objective assessment by the competent authority to justify retention, my lord. Now, the authority must justify why they want to, if the completion of project is the basis of retention, then it is the authority, it is the department authority who will say that no, at this stage, since this is at this progress level, so therefore, let us retain him first. Now, this is not the thing. This is the opinion expressed by the MLS, and the opinion expressed by the MLS has been simply acted upon. The notes at least ought to have explained.
No, we are not having the complete hearing today. They'll have to be given notice to make their submissions.
But at least at this stage, interim order, Malan. But if the interim order is not granted today, my lord, I'll be highly prejudiced. So, my lord,
Heard. Mr. T. Patel, Learned Counsel for the petitioner, as well as Mr. R.S. Nawam, Learned Additional Advocate General for the state. Respondent number 1,
1, 2, and 3.
1, 2, and 3. And Mr. Peter Apple and counsel appearing for respondent number 4.
And I'll take steps on 5 and 6.
Hmm?
5 and 6.
By filing this repetition under Article 226 of the Constitution of India, the petitioner has assailed the
Modification order.
2910. Where is that?
Page 48, my lord.
Order dated 10/11/2025, issued by the Secretary, WRD, Government of Arunachal Pradesh, thereby partly modifying the order dated 17/10/2025 and thereby retaining the respondent number 4 at
My lord,
Yingkiong WRD division as executive engineer and transferring the petitioner from SEPA WRD division within bracket under order of posting to Yingkiong KIONG Yingkiong WRD division bracket close to Daporijo WRD circle as executive engineer within bracket P&D bracket closed, page 48. You should notice returnable on what time, how much time you need?
Subject to my lord, how fast he can take his step to respond 5 and 6, my lord.
So far as you are concerned,
My lord, within
State-
3 weeks, my lord.
returnable on 10/11/2025. Requisite extra copies of the requisition be served on the learned Additional Advocate General. Next, by the petitioner shall take steps within 2 days for service of notice on the respondent numbers 5 and 6 by speed post with AD. Next, by the learned counsel for the petitioner is at liberty to collect the postal receipt numbers from the registry and submit postal track report prior to the next date of listing. Next para, heard both sides on the prayer for interim relief. Next para. The learned counsel for the petitioner projects that under the transfer policy applicable in this state, a government servant can be transferred after completion of 2 years at a place of posting. Stop. He was transferred to Office of SE Coord. It's Coord is coordination.
Yes.
Coordination, WRD Itanagar as executive engineer within bracket P&D I give the date 11/7, by order date 11/7/2023. And within 15 months thereafter, he was again transferred by order dated 29/10/2025 to Yingkiong Division as executive engineer.
There is one more, from Itanagar to Seppa, from Seppa to Yingkiong, page 36, Malak.
36.
36, Malak.
Okay.
5th August. Just 11 months.
And after a year, the order dated 5/8/2024, he was transferred from no, something is wrong then.
But I think he was transferred from Itanagar to Basar, then again from Basar, I did, order, I think I.
He was transferred from Basar.
Yes,
So, within a year, he was transferred
to Basar, and then again,
as to WRD Division, Basar as executive engineer. And within the same year, he was, and immediately thereafter, he was transferred from WRD Division Basar to SEPA WRD. What is DIC? Page 36, DIC means?
division, so Malad, it should be DIV.
Okay,
division, yes,
WRD Division as executive engineer.
5th August. Malad.
And within a year, he was again transferred by order dated 29/10/2025 from
Seppa to Yingkiong. Yes,
SEPA Division to Yingkiong Division as executive engineer. First off, it is projected that the petitioner was relieved on 4/11/2025 by the relieving officer, and he had entered over the charges. And on 6/11/2025, he had requested the superintending engineer, WRD, Panging Circle, to allow him to hand over, to take over charge as executive engineer. Stop. It is also projected that thereafter by a message. This is telephone message, WhatsApp message. WhatsApp message to the respondent number 4. Informed him that he would be coming to take over charge on 7 or on the next date. So stop. The Learned Counsel for the petitioner submits that the said message was sent on 6/11/2025, and on 7/11/2025, the respondent number 4 was not available, and therefore, in terms of the office memorandum dated 13/2/2007, the petitioner took over ex parte charge of his office, of his transferred office, of the office to which he was transferred. Post of relevant paragraphs 2, 3, and 4 of the said OM dated 13/2/2007 is quoted below, page 45. Full stop. Thereafter, on 10/11/2025, the Secretary WRD, Government of Arunachal Pradesh, issued the impugn order to retain the respondent number 4 at WRD, the Yongkyong WRD division as executive engineer and transferring the petitioner to Daporijo WRD circle as EE within bracket P&D. It is projected that the said transfer had occasion because of what is the full form of UO?
Unofficial.
Unofficial?
Yes.
Acha,
Unofficial.
unofficial note. Okay. It is projected that due to unofficial note, dated 31/10/2025, issued by the MLA, 34 TUTING dash Yingkyong YING Assembly Constituency, and UO note dated 1/11/2025. Something is wrong here. Page 50.
It is dated 3/11, again
No, but
down below, but then in the noting, it is already reflected that his note also. There are 3 dates, my lord. This, he signed on 3/11,
But how the note came to be made on 1/11?
yes. My lord, now in the page 51, already there is a mention of this note was initiated on 30/10.
Something
This
wrong?
noting,
You're moving in advance.
yes.
Can't go advance. Something is wrong. You lost this correct, man. Official note said 3010, whereas his
Signed on,
sign on 311.
and this is dated 1/11. So
No,
manipulation,
but you see this note at page 51,
Yes, ma'am.
this 51 note travels back and it goes to 7/11.
oh, yes, my lord, yes.
This is 7/11.
Yes,
Note is below.
yes, my lord. I'm sorry, my lord. This was earlier
711.
noting, yes, my lord.
711. That is correct.
Yes, my lord. 7/11 is correct, my lord.
But how this note of 3/11 is entered as 1/11, page 50?
This must have been prepared on 1/11, but he signed it on 3rd after 2 days.
No,
51.
Page 50.
so why you note dated 1/11/2025, which is purportedly signed by the
So typed out only
concerned
one
MLA on 3/11/2025, comma the same was by the MLA, comma 40 Geku GEKU Mariang MARYANG Legislative Assembly Assembly Constituency, comma the concerned authorities considered the set to UO notes, comma resulting in the issuance of an order of transfer, which is impugned in this writ petition. Next, in support of his submissions, And to press for the prayer for stay of the impugned order, the learned counsel for the petitioner places reliance on Dutta 1-2. Huh? This Gumon Singfo you have given. Yes, ma'am. And Zakir Hussain.
Yes, ma'am.
These are two you have given.
Another one is that 1997 1 GLT.
This will be number 3. 1, 2, and 3. Next, madam, I'm feeling hot. This is, I think, not to give. I'm feeling hot. Uh, Opposing the prayer for interference with the impugned order, comma the learned additional advocate general has submitted that it is quite permissible for a elected representative of the people to make recommendations for retention of an officer within within their constituency in view of the interest of the ongoing projects. And therefore, in view of the ratio laid down in the case of 2007 8 SCC 150, comma, there would be, it would be permissible for the transfer to occasion on the strength of the notes issued by the local MLAs. Most of it is further submitted that the guidelines would not come in the way of the authorities to order transfer prior to the period prescribed in the guidelines, as the guidelines do not create any embargo for the transfer, and the guidelines would not give a right to the petitioner to challenge the impugned impugned transfer orders. Full stop. In this regard, he also relies on the case of Puno Verma, PWNAM, Puno Verma versus Delhi Development Authority, AI 2008 SC 870. And accordingly, it justifies the order of transfer. Next, the learned counsel for respondent number 5 to 4. Yes. 1 and 2, R4, 1 and 2 has submitted that the racial let down in the case of Muhammad MOHD, Muhammad Masood MASOOD, Ahmed AHMAD within bracket Supra has been followed with approval in a relatively recent judgment of the Supreme Court of India in the case of Sri PUBI, Lombi LOMBI versus the state of Arunachal Pradesh, SLP Civil number 22074 of 2023. And therefore, and further laid down that in the absence of any pleadings of mala fide, non-joining of the person against whom allegations are made, and violation of any statutory provision, and 4, the allegation of the transfer being detrimental to the employee who is holding a transferable post, it has been held that judicial interference is not warranted. And a coordinated bench of this court in the case of engineer Michinibo within bracket Supra has also followed the ratio laid down in the case of Muhammad Masood Ahmed within bracket Supra, holding that there cannot be any hard and fast rule that every transfer at the instance of an MP or MLA would be vitiated. That's all. Anything incorrect in the submission, recording of submissions?
My only submission is that in Muhammad Masood case itself, they have clarified that other solitary decisions are, I agree with that. But here it provides that unless it is shown as mala fide, the Muhammad Masood case itself.
Not mala fide, it says complaint, public complaint. Okay. I'll think over and pass the final order, whether to stay or not to stay.
On this, my lord, my last application, my lord, there should be
Shakespeare-
2%, my lord. Either your lordship stay or stay may be rejected, my lord.
Shakespeare said to be or not to be, that is the question. So,
My lord, there is no administrative justification. That is my.
Now, why I'm saying because if your lordship passes any, my lord, status quo order, because both will be claiming, my lord, I'm still continuing, my lord. So.
you're right, you're right. I normally don't,
Arya par.
I don't subscribe to this status quo.
Status quo. my lord.
Hardly I have passed any such order,
My lord. Yes, sir.
especially in transfer.
Sir, my lord, is Arya par.
Eh?
Arya par hona hai.
Oblige, my lord. Okay.
Take it,
My lord,
we can come back.
my lord, item number 4, it's mine. My lord, actually, I have some difficulty. I have to go and rush somewhere. May I pray that this may be taken up on Monday or Tuesday, my lord?
Not Monday. Have it Tuesday. Okay.
Tuesday, Wednesday, next week?
Okay. Item 4.
4.
Who's for the other side? Item 4.
Jana.
Tuesday?
Wednesday?
18. Tuesdays will be DB.
My lord.
Tuesdays will be DB.
Tuesday is DB, yes.
Then Wednesday.
19th.
Both sides are represented. On the prayer made by Mr. T. Patil and counsel for the petitioner, list on
18.
it will be
19,
20,
Wednesday 19.
19,
19.
11,
19.
25.
Obliged, Lordship.
My lord, I will mention for adjournment, item number 20, for adjournment, item number 21. Step is not completed. Item number 21 for adjournment.
You are paying for adjournment,
Yes. Item number 21.
21.
Yes. I may be allowed to take a step on respondent, private respondent number 5.
Okay,
One,
just
two.
a moment.
Yes.
Item
1, 2.
21.
Step on respondent number 5 is not completed, so I may be allowed to take press step on respondent number 5. 1 to 3 is represented today, and TCR is also submitted. This is regarding the
Just a moment. No, according to the record, notice is served. You did not check the record.
Your Lordship, the notice upon respondent number 5 is pending. 2, 3, and 4 has already appeared.
No, look at this. That's why I normally don't pass orders without verifying the records. The officer in charge has given the report. It's in the last part of the record. Look, there's 1, 2, 3, 4 tick marked. Signed by somebody. Oh, there are four pages. Every notice is tick marked. You have found it.
My lord, moreover, this is joint FIR. Joint FIR by 4 persons. 3 persons are represent. Only one is remain left.
It's been served. You don't. If you
Yes.
don't understand, how can I can
Yes,
make you understand?
I got understand.
Then
Page per last order, so I rely on last order.
you always should check the record. Why should I spend the time for looking at the record?
So, big sport hearing.
No. We'll pass orders when item is called. Not now.
Okay.
This is when I call the item. Later when it comes. It'll go here. This is the record. Keep it here. It will go along with this. No, it's this only. Not this. No, this is today. Just today that this matter, Mr. Tafo's matter. This is the replication. No, this is different. No, this will go ahead with that. That same item, Mr. Ferdinand, Mr. Tafo. This matter. This is item 8 now. Item 8.
Item number 5.
181.
181, okay, 5. Yes.
I think the counsel for the petitioners are absent, Your Lordship.
But what has happened? These reports are not coming.
Your Lordship, we have filed our affidavit, Your Lordship. It was on.
When? No affidavit is filed to bring on record. They will ask for the personal appearance of the officers.
Yes, Your Lordship. Your Lordship, as per our instructions, Your Lordship, the petitioner is not cooperating at all, Your Lordship.
181. You have a supplementary file for affidavits? No. Has to be.
Yes, Your Lordship, we have filed, Your Lordship. It was
It's
on
there, it's there, but
16
that file
file.
has not come.
Okay, Your Lordship.
It's okay. 6.
Yes, Your Lordship, we have already complied, Your Lordship.
Yes.
It's affidavit dated 16/5/25, Your Lordship.
Okay, none appears on call for the petitioner. However, Mr. Y. Ram, the government advocate, is present. So he submits that pursuant to earlier orders of the court, by filing an additional affidavit on 16/5/2025, the respondent number 3 has brought on record the
Inquiry report, Your Lordship.
what does PI mean?
Uh, Public interpreter, Your Lordship.
Huh?
Public interpreter.
Acha. Public interpreter report.
Sorry, Your Lordship. Political interpreter, Your
It's
Lordship.
a political
Yes, Your
interpreter. Report. Indicating that on verification of the entire stretch of CC Road constructed by PWD was at a distance of at least 1 meter from the stone boulder wall. And the gap between the road and the stone boulder wall at few locations were up to 2 meters. And at no point of the entire stretch, the road was found to touch the stone boulder wall. Moreover, the head Gangura of Ramsing, RAM-SING village, Ramsing village, the stone boulder wall was already in a dilapidated condition and was already damaged at a few locations. And there was no, and the CC drain, CC means?
Cemented drain, Your Lordship.
Okay, what?
Concrete cement drain, I
Concrete
think.
cement, okay. The CC drain claimed to have been constructed by the petitioner was nowhere visible at the location. And even the Gambura had stated that he had not seen any drain at that location. Full stop. Next paragraph, the said statement is noted. Next paragraph, for Angel Justice, the matter stands adjourned today. List after 2 weeks.
Obliged, Your Lordship.
Item number 6.
None appears on call for the petitioner. However, Ms. T. Jeannie Leonard, APP, is present. Full stop. As per the office note, dated 13/8/2025, additional affidavit as required by order dated 5/5/2025 and 13/8/2025 has not yet been filed. And accordingly, the order of acquittal of the petitioner in POCSO case number 7 of 2023 has not been brought on record. Next paragraph. Foreign Justice matters to adjourn today, just after 2 weeks.
Deep law.
Item number 9.
May I update you, Lordship?
Yes.
My lord, in this matter, my lord, what we are praying is there was a land was acquired for a frontier highway.
Just a moment. Something is wrong. Come to page 2. You are asking for a stay of 2015 tender.
Well, we are not pressing that IM, Your Lordship. In fact, that was filed long back because the land which belongs to the petitioners, so that they have not taken the award, saying that there was no proper survey and there has to be re-verification.
Close this matter.
Yes, it can be closed, Your Lordship.
In that case, may I ask Your Lordship, this matter is being pleaded by the.
No, this has to be closed if he's not pressing it.
Okay.
Upon instructions, Mr. S. Moe, learned counsel for the petitioner, applicant. So means that the petitioner is not pressing this interlocutory application. Next, Mr. Y. D. Ram, learned counsel for the state is present. You're also there?
Yes.
For
the union opinion.
And Mr.
Number 5.
And Mr.
And Shora. On
S.
behalf of
Gaurav, and you are CGC.
No, on behalf of M. Kato.
Acha, learned counsel appearing on behalf of Mr. M. Kato, the DSGI. For the Union of India, you're also there?
Next.
And Mr. M. Kato, learned counsel appearing on behalf of Mr. R. Saikya, standing counsel for PWD Highway are present. Next, the matter stands. Close is not pressed. Yes, now.
Yes, in this writ petition, what we have prayed in this writ petition is that the award has to be made available to the petitioners, because the award was not displayed and it was not published even in their websites. So we have showed that the award should be made available to the petitioners, especially the land beneficiaries who are the petitioners in this writ petition. So it can be, Lordship may dispose the matter directly to the respondent
In that case,
authority.
Your Lordship, I have a prayer, Your Lordship. Since this matter is being pleaded by Mr. N. Ratan, Your Lordship, so he is not present today, Your Lordship. So may this matter be fixed next week, Your Lordship.
Okay. Where's the affidavit file? Send both the files always, huh?
Well, affidavit, they have not yet filed, my lord.
Yes, it's filed.
Okay.
Oh, it is kept here only. Okay. It's kept here only.
On
This contains this Annexure B, page 153, the preliminary notification. You are saying that the notification was not published, but it has been published.
No, award, my lord. Award has to be made available to the land beneficiaries and it has to be in the local websites. As per section 30, 7 is as per this Lara Act. The provision is here, Your Lordship. But then award, we have filed many applications to furnish the awards,
Not being given.
but then they have not given to the land beneficiaries.
Okay. Who's appearing for PWD? You are appearing for PWD. You have a copy of the affidavit of the government? No.
Yes, I have, Your Lordship.
Show it to him. See paragraph 14. Now, Mr. Hiram,
Yes, Your Lordship.
you have a copy of the writ petition also?
Yes, Your Lordship, I have.
See paragraph 15 at page 21.
15.
You see, he requires the documents that is here. Number 10, copy of the publication or award, maps, everything. Correct?
Yes, Your Lordship.
Now, look at paragraph 14, which I am showing to you from there, that affidavit. No communication received from the requiring agency. Requiring agency doesn't pass an award.
Yes,
So your deputy commissioner is making a false statement. We'll issue a notice of contempt against him.
Your Lordship, that's why I'm praying, Your Lordship, maybe fixed some adjourn for today.
We'll adjourn it, but you see this circle officer is making a statement again here. I have earlier also disclosed, this is something I can't accept. He can't have personal knowledge. He doesn't say anywhere that he has perused the records. The deputy commissioner has handed over the records to him. He has perused, and then he's making a submission. Come to page 150, or that paragraph 22. Circle officer says paragraph 14 is to the best of my knowledge.
Yes, Your Lordship.
Fundamentally, the affidavit is incorrect. It is not through his knowledge, his acquired knowledge. He perhaps went to the file and tells that this is what is there in the record. If he has personal knowledge, that means he has been interacting. He'll have to show that, yes, I was the person, I am the circle officer, I was interacting with the requiring agency, and therefore I have personal knowledge.
Yes, Your Lordship.
This affidavit is something I can't accept. You know, you see, he's just wanting a document, and then the deputy commissioner says so many things through circle officer.
Yes, Your Lordship.
Doesn't give the document. Heard. Mr. Small and counsel for the petitioner. Also so and so, same respondent so and so. Next para. At the outset, the learned government advocate prays for a short adjournment as the government, as the learned government advocate who is assigned with this matter is not available today. Next para. As per prayer B of the writ petition, the petitioner is seeking a direction upon the respondent number 4, i.e. the Deputy Commissioner, East Kameng District, to disclose the complete details of award. First of, in paragraph 15 of the writ petition, the petitioner has made a specific averment that in the letter that eight 4/2025 within bracket annexure 10, entire information was not disclosed. And that the Deputy Commissioner has not taken up the matter seriously, and it is alleged that the Deputy Commissioner did not take up the matter seriously and submitted incomplete. What do you mean by this English? I don't know. Letter mentioned did not take something in incomplete shape. What do you mean by this statement?
Which one, Your Worship? Which one?
Para 15.
Para 15.
Last 3 lines. What do you mean out of that? There's the letter mentioned the DC did not. What do you intend to mean by that statement?
Implemented respondent. It is to be noted that one.
No, I didn't understand anything out of it. The letter mentioned the DC did not take up the matter seriously and submitted incomplete shape without enclosing required document. I couldn't follow it.
I mean, I think, Malad, they have submitted series of representations.
No, you see, it doesn't make sense. This letter is 8/4 is by AE. AE means assistant engineer. Letter is to executive engineer. Executive engineer, I don't know what is being intended. Where is this 10? And 10 is which page?
126. 126.
Well, I will take to 104. There is a one annexure. There is detailed representations petition.
You are referring to 10. Let us understand 10.
10.
Stating that the letter of the Deputy Commissioner was found in incomplete shape without enclosure of required documents as per guidelines and specifications of Manual for Land Acquisition in Arunachal Pradesh, 2022. Stop. Next, the learned counsel for the petitioner is that till date, a copy of the final award has not been furnished to the petitioners or published by any authority in a manner prescribed under the relevant act. Next para. The court finds it strange that the statement made in paragraph 15 of the writ petition though replied at paragraph 14 of the affidavit in opposition filed by respondent number 4 through circle officer is instead of responding to the concerned paragraph, comma, vague statement has been made that no communication was received from the requiring agency, which does not convey any meaning. Full stop. It is next paragraph. It is seen that the said affidavit by respondent number 4 is sworn and filed by the circle officer who has not stated that he has personal knowledge of any transactions or communications made in the office of the Deputy Commissioner, East Kameng District. Post stop. She is not also stated on oath that she has acquainted herself with the records in the office of the records of the office of the Deputy Commissioner in connection with the said land acquisition proceedings. But the statements made in the affidavit is verified to be true to her personal knowledge. Except paragraph 9 and 11, which are stated to be information derived from records. Full stop. Therefore, the next paragraph, therefore, comma, the respondent number 4 is put to notice that the affidavit filed on his behalf does not inspire confidence of the court. As the replies are very vague. And therefore, the said authorities put to notice as to why the said affidavit shall be treated as insufficient and discarded. Next paragraph, the learned government advocate shall send a download copy of this order to the respondent number 4 to put him to notice of the order. Next paragraph, the pendency of the writ petition shall not be a bar for the respondent number 4, I, the Deputy Commissioner, East Kameng District, to produce the documents referred to in paragraph 15 of the writ petition in an appropriate manner by filing an additional affidavit. By filing an additional affidavit in a manner deemed fit and proper. That earlier manner don't write, huh? In a manner deemed fit and proper. Next paragraph, list after 2 weeks. Give date after 2 weeks.
3rd of December, 3/12.
Oblige. Your Lordship. Oblige, Your Lordship.
Item number 10.
Because Mr. Iran, whenever I look at it's a normal habit to look at the affidavits.
Yes,
And I start looking at the affidavit from the verification part.
pardon, Your Lordship.
I first read the verification part,
Okay.
then I read the affidavits.
Yes, Your Lordship.
It's a bad habit.
No.
And the mind is trained on order 6 rule 5.
Yes, Your Lordship.
Vague response is no response at all. It is an admission.
Indeed, Your Lordship.
So something which I can't shake it off from my mind.
Yes, Your Lordship.
Admission and denial is something it's ingrained. I find it very difficult on these affidavits. Authorities were not acquainted, not notified.
Yes, Your Lordship. Oblige, Your Lordship.
Item number 11.
Item, no 10.
10. Item number 10.
There is no representation from the petitioner. For ensure justice, the matter stands adjourned today. Just mention, Mr. White, Mr. T. Wangbu, the government advocate is present. And Judge Justice, the matter is adjourned today. List after 2 weeks. Yes, have you information whether the representation disposed of? They want only the representation to be disposed of.
My lordship, they have not served the extra copies also, my lord. They are not present.
They're not giving you copies.
Yeah.
Judge's record is written, she's present and submits that till date, extra copies of the representation has not been served on her. And accordingly, she is unable to obtain instructions till now. Next paragraph. Learned counsel for the petitioner shall, in the meanwhile, serve requisite extra copies of the representation to the learned government advocate. Just to enable her to obtain instruction. Within 2 days, you said within 2 working days to enable her to obtain instructions, just after 2 weeks.
Item number 11.
May I please, Your Honor? Your Honor, on last occasion, I am prayed put does this service upon respondents, my lord. However, same has been not done, my lord. So I may be allowed to take Dasti upon
No, not
respondents.
Dasti, you sir, give by registered post. Dasti will not help you. The
Register post as well as Dasti service.
No, first of all, you see the process has been returned back with the mark not found. So if it is not found, you'll have to tell us what the address is. You yourself took time, I think more than a year time has gone by
Yes,
for
sir.
taking steps by the state. If you don't bring on record, we can't issue any order for service. Has to be at a proper address.
In this case, my lord, I may be allowed to find it at proper address, my lord. Then
Yes.
after I will take.
For Mr.
M. Doji, my lord.
M. Doji, and counsel for the petitioner. The affidavit regarding Dasti service has not yet been filed as per office note dated 18/11/2025. Next para. It may be mentioned that the steps, the process issued on the respondent numbers, respondent number 1, 2, and 3. By registered post has been returned back with endorsement in respect of respondent number 1 as not found. The second process to respondent number 1 is found to be returned back with postal endorsement, insufficient address. Again semicolon, the process issued to respondent number 2 has been returned with the postal note of addressee left without instruction. And the process to respond number 3 was returned with postal endorsement, addressee moved. Full stop. Thereafter, going to the delay in taking steps. The court by order dated 28/10/2024 had recorded that if no steps are taken, the matter will be treated as dismissed for want of steps. Full stop. Thereafter, when the matter was listed on 2/12/2024, the learned counsel for the petitioner produced the copy of Tagabana disclosing steps taken on that date. However, since then the matter was listed on 5/2/2025, 2/4/2025, 26/5/2025, and 19/8/2025, the proof of service or notice by Dasti, which was ordered by order dated 2/4/2025, has not been filed. Next paragraph. Accordingly, the the petitioner is directed to bring on record the correct postal address of the respondents by filing an additional affidavit. Only thereafter, notice the orders will be passed for issuance of notice. Next paragraph. The petitioner is put to notice that in the event the affidavit to bring on record the correct postal address of the respondents is not filed, the court may revisit the interim order which was passed by order dated 29/7/2016 and last extended until further orders by order dated 12/5/2020. Next, we are awaiting filing of affidavit to bring on record the correct postal address. List on, give a date after 2 weeks.
9/12.
Yes. All right.
Item number 15 and 16.
May I please, Lordship? Lordship, this settled matter in between the parties, Lordship. Issue is only there was a physical assault in between the restaurant owner and the customer. But that has been locally settled. So we have already annexed in page number 18, annexure 2, Lordship, the settlement. FIR is in page number 15, Lordship. So what happened, Lordship, in this case? We have, after that lodging of FIR, matter has been locally settled outside the court, but during the thereafter, the jointly filed petition before this honorable court for quashing of the FIR. However, in that period of time, Lordship,
No,
what happened?
yes, there's a difficulty because we couldn't follow it. You are saying that there is a settlement,
Yes, sir.
but this court required an interlocutory application to be filed to bring the charge sheet on record.
Lordship,
what is-
that is already we have Lordship filed. Lordship. Copy I have additional affidavit.
No, the court required an interlocutory application. So I was searching for interlocutory application. Why would you file an affidavit? But where is that affidavit? You filed it when?
Lordship, I have copy, Lordship.
When did you file it? You see, we go by the order sheet. Okay, it's there.
Lordship.
It's there, 7/8/2025. Okay, where is the charge sheet?
Additional affidavit, Lordship, we have submitted the charge sheet also.
Spectacle broken, blue kurta, torn. Offense under section this.
Section is Lordship in this case. Section initially police has registered section under 115, clause 2 of BNS.
BNSS.
Yeah. Section Lordship 115.
Just wait. I have.
All right.
Unless I know the offense, I can't say that it is compoundable or not.
All right. All right.
Yes, please take it up. 115. 115 voluntary causing hurt. Second is 74. Assault. $74, cognizable, non-bailable, 5 years. Then 351(3).
If it was a criminal intimidation, Lordship.
351(3). Nature of punishment?
Nature of punishment is Lordship imprisonment.
7 years.
Yes, extend to 7.
In the new act, where is the description of compoundable offenses? We had 320 earlier.
Lordship, out of these sections, Lordship, only 2 are non-compoundable, Lordship, 74 and 296 BNS.
These are non-compoundable.
Yes, Lordship, and rest are compoundable.
Okay. Now, where is your agreement?
Agreement is Lordship page number 18. Page 18.
18.
Yes, Lordship. Annexure 2. Page number 18. Lordship. Annexure 2. In the agreement, Lordship, the complainant, including victim and accused, 4 persons, Lordship, they have made agreement and it has been registered before the notary. So now, Lordship, the parties don't have any dispute. So this matter is pending from the September 2024 till then. So therefore, Lordship, my prayer is to quash this charge sheet, including this FIR, in interest of justice, Lordship.
Where is the FIR?
FIR in Lordship, page number 15, Lordship.
15.
Yes. FIR, Lordship, while lodging the FIR.
Yes, Mr. Again.
Lordship, as per the Lordship, information Lordship, this already charge sheeted Lordship, both the cases 15 and 16, they both are Lordship, they are parties Lordship, same parties Lordship, but two subsequent FIR was Lordship, two FIRs Lordship, out of same
You see
incident.
the difficulty, you see, what is the difficulty? I will tell you why we are searching out so many things. You see, so far as the court is concerned,
Lordship.
we do not know the identity of these four people. Correct? The victims, three victims and the petitioner.
Lordship.
Now come to page 19. In 19, somebody has made the signatures of this. Now, who are these persons who are signing? We don't know the identity.
Lordship, there's an additional affidavit, page number 31, it's mentioned, Lordship.
Page 31.
31, Lordship. Additional affidavit, Lordship, include police charge sheet. This petition number 4 is Tadir Kapa, is the accused in this case, Lordship.
31. Yes,
Yes.
where it's there?
Page 31 below, Lordship. Last paragraph, under the fact and circumstance, I would like to submit the Papu Hill PS
Something
case.
wrong you are reading. Page 31 in my record is Papu Hill PS case number so and so statement recorded under section 180 BNSS of Srimati Geeta Angu.
Okay.
You get the point.
Lordship.
Supposing we close the matter today, and then tomorrow somebody comes and says that, no, I was not the signatory. How do we assert the proof of
No, Lordship. The parties already settled the matter, Lordship. And then
No, we are not saying that you're making a false statement. Please don't misunderstand us. But how we assure to ourselves that these are the persons who had made the signature, are the persons who are the informants or victims.
Lordship, I'm giving assurance, Lordship.
Your assurance doesn't matter to us. Did I tell you that your statement is false? No. But we have to assure ourselves that the identity of the persons are correct.
Lordship, in affidavit also, Lordship, they have submitted their four affidavits, Lordship. The person they have voluntarily signed.
No,
affidavit.
today I can, if I request any of my, your friends, may not be here, but if you request any of your friends to get us a affidavit of the, what you call the Chief Minister of the state, he will get it immediately.
Lordship,
May not have been signed by him, but he will get it. I am not accusing you of anything, but we want to assure to ourselves that these are the persons whose identity is not in dispute.
Lordship, issue is only very simple, Lordship. There was.
Can you get information from the police station?
Lordship,
The local police station, whether they can ask this informant, the what you call the victim, if they have settled it. Because you see, no proof of identity or other things are enclosed.
Lordship, party have settled, they have.
No, we are not for moment saying it's not settled.
Oh, no, Lordship, matter may be adjourned, Lordship.
You show us the proof of identity of these people.
Lordship, otherwise personal appearance करेगा.
No, not personal appearance. We don't want in High Court personal appearance. You can be
Because,
satisfied.
Yes, Lordship, I will take the instruction, Lordship.
If they come, they can attend your office and you can satisfy yourself. But in the court to make people
Lordship,
stand,
in our office, Lordship, we can do that, Lordship.
you can do that.
Yes, Lordship. On the last occasion, one matter also, Lordship, they have some some kind of confusion that they come to our office so that identified way, Lordship.
No, because you see, when we accept this and close the matter,
Yes, Lordship.
somebody's right to prosecute would go away.
Yes, Lordship.
So we want to assure ourselves that the identity of the person is not disputed. We produce before the office.
All right, all right. Definitely,
Within how
Lordship,
much-
I will produce.
Within how much time? By when?
Next week, Lordship,
Okay, suggest a date, we'll fix it on that day.
Friday. Next Next Friday.
Next Friday. Okay.
27. Lordship.
Both her Mr.
T.
Topul and counsel for the petitioner, as well as Ms. El Hagil and APP for the state. Next para. It is submitted that the victim and the accused have compromised the matter outside the court, for which reliance is placed on an joint affidavit by the parties. Full stop. Next para. As in order to assure ourselves, to ourselves the identity of the persons, specifically the victims, the court is inclined to direct the learned counsel for the petitioner to produce the alleged victims before the office of the
Public
prosecutor,
prosecutor.
who verify the identity of the persons and report to the court. Next para, the learned counsel for the petitioner has submitted that he will be in a position to produce the victims before the office of the public prosecutor on 21/11/2025. Full stop. List on 24/11/2025. So same day, make it 24, same day. 20. Or 21. We're listing on the same day. You just check the identity
No, sir.
and just add there, just recount that language. we have said somewhere that we has to assure ourselves the identity of the persons. huh? And accordingly, the learned APP has suggested that if the victims can be produced in the office of the public prosecutor, just change that language.
Lordship, item number 16 also similar matter, Lordship. Just the counter FIR only.
15.
Yes, 15, 16. It is similar, only just counter FIR, same.
Parties are same, Lordship.
In item 15, you said
Same.
list on, both sides are represented, list on, that same 21, 11, 20, 25.
Yes,
If the identity is same, we'll close
Yes,
the matter.
Lordship. Then, Lordship, and both the 15, 16 may be
together.
clubbed together.
Same.
Yes, Lordship.
Along with so and so.
Yes.
much of it.
Obliged, Lordship.
We'll continue post lunch. Normally in the principal seat, the identity of the victims and all, there was all produced. So there's no confusion with the identity. It's very difficult to close the matter. You think for the other side. If it close, then what happens? And we don't want to record your, what you call your statement, because then you will be not only in contempt. The court will, if something wrong happens, will also have to lodge an FIR against you. You understand the problem?
Yes.
That's why we don't want the officers of the court to give undertakings and be recorded. Once it is recorded and it turns out to be incorrect, I'm not accusing you of anything, but if it is incorrect, then you land in a bigger problem.
Unlisted item number 27.
My Lordship,
Yes.
Your Lordship, this is a bail application, Your Lordship. On the last occasion, on dated 7/11/2025, it was listed for motion. During the motion stage, Your Lordship, the name of the respondent number 3 was having slightly mistake.
Okay.
So, Your Honor,
You made the correction now?
Your Honor, in the order, Your Lordship, it is inadvertently mentioned as respondent number 2 instead of respondent number 3.
Oh,
So that may be corrected, Your Lordship, and I may take steps further, Your Lordship. Stay the line.
Miss
T. Rini, Your Lordship.
T. Rini,
Yes.
learned counsel for the petitioner submitted that there is a typographical error in mentioning the name of respondent number 3 and by order dated 7/11/2025, this court, while allowing the petitioner to take to correct the spelling, inadvertently recorded such order against respondent number 2. Full stop. Say Nagel and government advocate, learned APP is present. Next, brother. Accordingly, the prayer made by the learned counsel for the petitioner is allowed. Instead of making correction in the name of spelling of the respondent number 2, or the learned counsel for the petitioner is permitted to make appropriate correction in the name of respondent number 3.
3, yes, Your Lordship.
3. Okay.
Uh,
Respondent number 3, Lordship.
This correction will be before whom?
Deputy Registrar Judicial.
So the correction shall be carried out in the presence of the deputy registrar within bracket judicial. So upon such correction being made, the matters shall be again listed before the court immediately.
Lordship.
You can type this order and send it here. We'll send the record today only. She can do it today. We'll see it can be transmitted today to this section. You can go and do it today only. Just wait for some time. We're not assuring you, we are trying to. We are not assuring you, but we are trying to have the order signed now so that we can send it to this section. But we are not assuring you. Correct?
Item number 17.
None represents, there is no representation for the petitioner on call. However, Miss, I'm sorry.
P. Sangeeta.
P. Sangeeta, Learned Government Advocate is present. So it is
On behalf of 2, 3, and 4, Your Lordship.
on behalf of respondents 2, 3, and 4. So for Angel Justice, matter stands adjourned today. List on. List after 2 weeks.
Yes, Your Lordship. Obliged.
Item number 18.
May I, Your Lordship? Your Lordship, in this case, Your Lordship, pleadings are already completed.
Yes.
Therefore, matter may be fixed for admission hearing.
When? When?
It may be fixed after 3 weeks.
Both sides are represented. The land counsel for the petitioner has submitted that pleadings have been exchanged. So next para accordingly list the matter in the admission column after 3 weeks.
Your Lordship, there is an interim that may be continued.
Interim order passed earlier stands extended till the next date of listing.
Highly obliged.
Item number 19.
May I please, Your Lordship?
Yes.
Well, this matter related to payment of admitted amount, Your Lordship. But affidavit they have filed by the government and respondent.
Yes.
But then, my lord, the respondent 1 and 2, they have filed the relevant paragraph 8.
Yes.
As per that affidavit, Your Lordship, it says that the money has not been deposited by the respondent number 4. I may just read 3, all right, 3. Page 46 of affidavit filed by respondent number 1 and 2. Paragraph 8. May I read just, Your Lordship?
We read that.
Yes. It says that they are not able to pay due unless NBS, Navadya Vidyalaya Samiti Authority, release the balance amount. The paragraph 8.
But they are not parties here.
They are party, my lord.
Navadya Vidyalaya Samiti.
Yes,
here.
I see it. Jeannie,
I'm representing
Jeannie is
BPS,
appearing. And they have also filed affidavit here also.
But who are they?
Petitioner, in fact, he has.
Where is Navodaya Vidyalaya Sangathan party here? Which respondent?
JNB, my lord. Jawaharlal Navadya Vidyalaya, my lord.
Where it is? Which respondent?
Respondent number 3, my lord.
No, respondent number 3 is general manager.
Yes.
General manager doesn't pay.
No, Navadya Vidyalaya Samiti is there.
That is an address.
Yes.
Can you file a writ petition for dues from PWD saying that general manager or the chief engineer PWD without making the employer a party. Employer is Navodaya Vidyalaya Samiti.
Yes, yes.
The employer is not a party. This officer who is a party, officer can't pay from his pocket.
Yes. My lord,
You have to impede them.
that Navodaya Vidyalaya Samiti, my lord.
Because you see, supposing you are the general manager today,
Yes, it may.
will you pay it from the pocket? No.
Yes, yes, that's true.
So
And then, my lord, can implement.
it's a technical problem, but impede them.
Yes.
But you have to file an application then. You are under the new notification of the High Court.
Yes.
If it is from the court, then it can be done. Otherwise, you'll have to file an application to do it.
Okay. Then I may be allowed.
Adjourning the matter.
Okay, I will.
That mention.
Yes, yes. I will implement that Navodaya Vidyalaya Samiti.
Mr. S. Mout and counsel for the petitioner has submitted that the respondent numbers 1 and 2 have not disputed the claim of the petitioner towards the admitted dues. However, a stand has been taken in paragraph 8 of the affidavit in opposition of respondent numbers 1 and 2 that the payment could not be made unless the Navodaya Vidyalaya Samiti authority releases the balance amount. Stop. Accordingly, as the said authority is not a party in this application, the learned counsel for the petitioner seeks leave of the court to file an interrogatory application to impede the said said authority. Stop. Next para. Ms. P. Sangeeta, learned counsel, learned government advocate, as well as Ms. T. Jini, learned counsel for the respondent number 3 are present. Next paragraph. The magistrates adjourned today. The same may be listed as soon as the application is filed.
All right.
Item number 20.
My lordship, we need some more time to file application.
Where is the copy of that civil appeal? Civil appeal number 954 of 2024. Where is that copy of that?
Page number 68, man.
47, Manoj.
47.
Connection, sir, yes. This is the judgment.
No.
Appeal.
Where is the memo of appeal?
Memo.
Proceedings of civil appeal 954 of 2024. It is not annexed here. You see, we'll tell you why we are asking for only that. Come to page 20. Here, prayer B, not to proceed with proceedings of civil appeal so and so.
My lord, Annexure 7, my lord.
Page.
65, my lord.
65. Sure. This delay occurred in respect of which the 1800 days delay, 1880 days delay, which is that order.
Should be page 104, my lord.
104.
Sorry, my lord, sorry. That is of the district judge, my lord. Sorry. Hmm. 122, my lord.
122.
Yes.
Swami, you were seeking adjournment for which respondent?
Respondent 1 and 2.
That's the state.
Yes.
And you are appearing for?
3, my lord.
Please keep the private respondent.
Yes, ma'am.
Yes. With whom the dispute is.
Yes, ma'am.
The reply of the government would not be necessary. The government will not be able to respond to it. Even if we give you 1 year's time, you will not be able to respond to it. You know the reason why? It's a question of law. Yes, what do you have to say?
My lord, the principle of limitation will apply, my lord.
Will apply.
Yes, my lord.
Under which provision?
MP still supra, my lord.
MP still supra.
Yes, my lord.
This shows that.
My lord. 2015, 7 SSC, page 58. MP still corporation versus Commissioner of Central
2015.
7 SSC,
Yes.
page 58, my lord.
58.
Yes, my lord. Paragraph 38, 43, and 52, my lord.
38
43,
and
52, 52, my lord.
52.
Yes. Principle of limitation will apply, my lord. Principle of limitation will.
Just a moment. Unless I look at the judgment, I'll not be able to say what does it say.
The issue raised by the petitioner is that, my lord.
We understood. That's why we are asking you from middle.
Yes, ma'am.
You're not asking the facts. You just started from the middle.
If principle is applied, my lord, then this writ petition is not maintainable, my lord.
Let us see this first.
My lord, I will be relying on two judgments. One another one. 2016.
Just one by one. Let me finish
Yes.
2015 first.
Yes.
This order was passed in your favor.
Yes, my lord. The delay was condoned, my lord.
Delay was condoned.
Yes.
Okay. And which court was the,
Civil Judge Senior Division.
no, this, against the order of the estate officer, where did you file an appeal earlier?
We filed civil suit, ma'am. Statute suit. Before the Civil Judge Senior Division, UP Award.
Where is the plaint? No, where is the plaint?
Page 32, ma'am.
It's 31. Okay.
Yes, 31.
So what is the second judgment you're relying on?
2016, 3 SSC, 468 page.
What is the name of the parties?
AP Power Coordination Committee versus MS Landco Kondapalai Power Limited. AP Power Coordination. Yeah, paragraph mark.
Yes, are you ready for hearing?
No, my lord. My lord, since the conducting council is debunking, my lord. So matter may be fixed for hearing, admission hearing.
So he's, okay. Okay, then next week. All sides are represented. For the prayer made by land council for the petitioner, the matter is adjourned today. List after a week in the admission column.
Yes, madam.
Item number 22.
So this one 21 also, I think. 21.
Item number 21. I forgot.
Yes, you wanted an adjournment.
My lord, I thought the
No, it's
step
okay.
not complete. Now step is completed. So matter maybe fixed for admission hearing.
Okay. It's a criminal petition. We have not admitted it.
It's a criminal petition for quashing of the FIR. The FIR out of same incident, here joint complaint, and they already filed the money suit and money was recovered.
The counsel for the petitioner, Kamal Leonard, APP for the state respondent number 1. And the Learned Counsel for respondent number
2, 3, and 4, Lordship.
2, 3, and 4 are present. Next, as per the service report returned from police station Sepa, East Kameng district, the notice by the registrar of this court on 28/5/2025 has been duly served and returned. None appears on call for the respondent number 5. Next, currently, list the matter in the admission column. When?
After a week. After a week.
After a week.
Lordship, after 3 weeks, meantime, I will file my objection, Lord. I need 3 weeks time to file my objection.
Okay.
So, matter will be listed.
Then you had there, the Learned Counsel for respondent numbers 2, 3, and 4 pays for some time to, pays for is granted 3 weeks time to file his affidavit in opposition in the matter. Next, list in the admission column after 3 weeks.
All right.
Item number 22.
No one is there. No representation from the petitioner. However, Ms. Tijini and APP is present. According to justice, the matter stands adjourned today.
Your Lordship, a small prayer, Your Lordship. On the last occasion, TCR was called for. The registry hasn't received the TCR yet, Your Lordship.
It's received. Next, as per office note dated 13/11/2025. Oh, not yet received.
Not yet received.
The TCR is not yet received. So accordingly, the registry shall do a reminder for the TCR. Which can be sent through the email of the Court of Additional District and Sessions Judge Masar. Why TCR is required this? This is a case of they are claiming that it is amicably settled.
Yes, Your Lordship.
Is TCR required?
Your Lordship, just to ascertain at what stage, Your Lordship,
Huh?
just to ascertain at what stage the trial is pending. In
We
case,
can only have the order sheet,
order sheet can also be done.
order sheet and charge sheet.
Yes,
They've already filed the charge sheet, I think.
charge sheet is already annexed here.
Annexed. And they have certainly visited as well. Next para. On a perusal of the records, it appears that the petitioner is seeking quashing of the FIR on the basis of a mutual agreement between the parties. First, oh no, this can't be. Why you did not point it out? This is a case of death.
Yes, Your Lordship.
It couldn't be. It couldn't have been. We cannot. Okay, so that's why I record. Don't say anything. Only the email address. That's how we could transmit the transport records. List after 3 weeks. Theodosius, can it be compromised? No, I don't.
Yes, I deeply apologize. I just received the file and I was going through. I also saw the 304, Your Lordship. I deeply apologize.
But the honorable judge recorded the provision,
Yes.
then called the inquiry.
Deeply apologize.
Item number 23.
This could have been entertained, ought not to have been entertained in the
Yes,
first
sir.
place.
Yes.
Case of death can't be compromised.
Yes,
Not
Your
only
Lordship,
in
absolutely.
guilty. Yes,
Item number 23.
this is an interlocutory application. Now, there is a call for the petitioner. On a perusal of record, it appears that this is an application under Section 5 of the Limitation Act, whereby the applicant has prayed for condoning a delay of 27 days beyond the period of limitation in filing the connected appeal. Expiration notice, returnable on 19/12/2025. Make it 17/12/2025. The applicant shall take steps within 2 days for service of notice on all the respondents by speed post with AD. List on. Assembly 17/11/25. This one. Sir, Mr. Mo or Ms. Ginny,
Yes.
can you request the bar someone from the bar, some authority from the bar, president, secretary, or someone may call upon the Honorable Justice P.K. Deka. He's the Lokayukta here now. He wants to meet the bar for purpose of spreading awareness of the said authority. Can you?
So yeah, I
you
can talk to
send across the
the
word?
secretary.
His office can be contacted and he'll be, he's wanting to come to the bar, meet
Good.
with the bar and then spread the awareness about, since the office has started functioning.
Okay.
He's,
It will be our pleasure to meet and interact with Justice P.K. Dekar.
huh. So, oh no, sorry, he's Human Rights Commission.
Oh, Human Rights Commission. Oh,
Sorry, sir, sorry.
recently appointed, Your Lordship.
You're the council?
Yes.
Yeah, it's especially in the PIL, Your Lordship.
Just a moment.
I know the member secretary also. I can also contact member secretary.
No, didn't. Oh no, he's the Lokayukta. This is Prashant P.K. Dekar.
Okay, Lokayukta.
Lokayukta.
Okay.
Because, I'm sorry, I made a mistake. He's a Lokayukta.
Okay.
So he's wanting to spread his awareness.
Good.
Will surely.
Can we?
We will make sure that we will make sure that we have a meeting with the bar.